Wyoming Pregnancy Center's autonomy and rights, and ask for your favorable consideration. Mr. Chairman, I do have a co-presenter that couldn't be present today physically, but she has joined me online.
Is that Burke?
Yes, sir.
Okay.
In the event that the committee has any specific questions that I could defer to her to, but I will.
And particularly, she's a legal expertise?
Correct,
So if
Mr. Chairman.
If we get, so if we get deep into the legal questions, that'll be our go-to.
Thank you, Mr. Chairman. With your permission, I'd walk you through the bill.
Please.
Thank you, Mr. Chairman. Mr. Chairman and members of the committee, House Bill 273, the Wyoming Pregnancy Center Autonomy and Rights of Expression Act, protects Wyoming pregnancy centers from discrimination simply because they do not offer, refer for, or counsel in favor of abortion, abortion-inducing drugs, or contraception. This bill proactively protects centers' First Amendment rights of free expression and free association, and ensures that they're able to continue to serve the women, children, and families of Wyoming. So the why the bill? Mr. Chairman, members of the committee, the threat to pregnancy centers is real and growing. States and local governments, often with the encouragement and cooperation of abortion advocates, are increasingly considering measures to restrict the free speech and religious freedom of pregnancy centers and taking actions that threaten to eliminate or limit the positive impact they have on women, babies, families, and the communities in which they serve. This act prohibits state and local officials from forcing a pregnancy center to perform or refer a woman for abortion. It ensures that ensuring that state and local officials cannot prohibit a pregnancy center from providing pregnancy care, counseling services, or any other service related to pregnancy, perinatal care, or postpartum care simply because it does not perform counsel in favor of or refer for abortion. Furthermore, it prohibits state and local officials from seeking to limit the free expression and free association rights. It provides for a legal remedy for pregnancy centers when their rights are violated. Otherwise, centers may be left with no recourse when the government tramples on their rights. Mr. Chairman, on page 2 of the bill, we go through some legislative findings that are listed there. Just kind of walk you through the content of this bill. Moving on to page 4, we have definitions. And then moving on to page 8, we have interference with pregnancy centers prohibited. So this is basically what I kind of already gave you a snapshot of when it comes to free expression. On page 10, at the bottom, starting on line 16, we go into legal remedies and right of intervention. Page 11, starting at line 15, granting immunity from tort liability and liability on contracts exceptions. And then the effective date is July 1 of 2025. And I would be happy to delve more into the bill if you'd like, or stand for questions, depending on the committee's preference.
Representative Rodriguez-Williams, on page 5 is the definition of abortion in this act, and I know we have passed a considerable amount of legislation dealing with this topic. How does this definition align with other definitions in statute of abortion? Is this consistent, or is it different? If it's different, how is it different?
Mr. Chairman, members of the committee, it is duplicative of legislation that we have passed, that the legislative branch has passed.
It's the same definition?
Mr. Chairman, members of the committee, yes, it is what's currently in statute for current definitions that are in statute.
Okay, and this just might be drafting wise, because typically what they'll do is they'll say abortion means as defined in statute, and then we would refer back to the statute. And that would usually help us to understand immediately that it's the same definition. Maybe they just didn't do that right here in this bill.
Mr. Chairman, fair enough comment. I can tell you in my own committee, we have looked at other bills that don't list out all of the language that's contained within statute. And it just, several of them just list the statute and defer to them versus, I guess, filling up pages, as you would say, with lengthy definitions. And I would adhere to your committee as to whether or not they want to make that policy decision.
Do you have the statute? You started to list off what the statute was. Do you have the statute that had, what is the where is this defined? Do you know? Do you have that statute?
Mr. Chairman, not off the top of my head, but I will tell you that
Oh, we got it. 35
should list it right in the beginning.
122, I think. Okay. But just so I understand your intent, if we are to do something to this bill, I want to make sure I understand your intent. Your intent is to have a definition consistent with the definition of abortion in existing state law. So if we were to make a change to it and say abortion means as defined in 35-6-122, I want to make sure that would align with your intent.
Mr. Chairman, yes.
Okay. Committee, other questions? Senator Kolb?
Yeah, thank you, Mr. Chairman. Representative Rodriguez, I always have a question about findings of fact. I guess if you could explain to me why you believe this is necessary to be in this document, I'd just like to hear why. Thank you, Mr. Chairman.
I had that question too. It's not terribly common, but it does happen. Representative?
Thank you, Mr. Chairman. I would state, Mr. Chairman and Senator Kolb, that personally, I am a fan of findings. I think that findings help our judicial branch of government if need be. I know that there's been a difference of opinion between the two chambers on findings. I can tell you that we have seen a lot of bills on our side of the chamber with findings. If you're seeking more of a legal expertise answer, I would defer to my co-presenter to chime in, if you choose.
Senator Kolb?
Yeah, thank you, Mr. Chairman. And the other question I had was, has this happened before in the state of Wyoming? I mean, have there been services like this that have been hampered or restricted because of, say, local ordinances or some sort of zoning issue? Could you give me the background on, I guess, why is this necessary? Thank you, Mr. Chairman.
Representative Rodriguez-Williams?
Mr. Chairman, Senator Kolb, thank you. So why of the bill? I mentioned earlier the increase that we're seeing nationwide, but I would also add that at least 1/3 of the nation has introduced anti-pregnancy center measures since the overturning of Roe in 2022. States included Arizona, California, Colorado, Delaware, Illinois, Kentucky, Massachusetts, Minnesota, Missouri, North Carolina, New Jersey, New York, Ohio, Pennsylvania, South Carolina, Texas, and Vermont. And there are other states that are pending. I would tell you, Mr. Chairman and members, that I believe there is a consensus amongst our legislative branch, that we support these centers, they're life-affirming centers that really truly have an impact throughout the state of Wyoming. I can tell you last year we did pass I believe it was a resolution or a proclamation, if I remember correctly, where the majority of the body did sign in support of the good work that these centers do. I hope that helps answer your question.
Sorry. On where the list begins of things that the state cannot require a pregnancy center to do, I've just always been curious about this. So like, just for example, in Romanet 2, it says not require a pregnancy center, cannot require a pregnancy center to offer, provide, or distribute abortion-inducing drugs or contraception. I find this throughout the abortion legislation that we have. I'm just always curious why we refer to it as a drug as opposed to a medication. Is there a reason why we do that?
Mr. Chairman, members of the committee, in all honesty, I don't have a concrete answer for you as to the why. I think that we probably each have our own opinion, perhaps, on the why. But again, if it were a decision of the committee to want to change that, I guess I would just ask that your decision be based on some sort of supportive evidence or expertise as to the why the change.
Okay. Anything else, committee? If not, we'll get to public comment. Okay, thank you.
Thank you, Mr. Chairman.
Anyone, any state agencies wishing to testify on this bill? Anyone in the room wishing to testify on this bill? Yes, please come forward. Welcome.
Hello, Mr. Chairman, members of the committee. Thank you for the opportunity to speak on House Bill 273. I am Sharon Breitweiser. I am with Wyoming Right to Choose. We are opposed to the bill. In response to a question from Senator Kolb, we too question whether this bill is necessary. These are nonprofit organizations that enjoy the same free speech rights as pretty much everybody else, you, me, other organizations. And we believe that by exempting one particular type of nonprofit organization from government oversight and regulation could be opening the door to a wide-ranging flood of other organizations that may come in and seek similar peremptory relief. So respectfully request your no vote on this bill.
Any questions for Mr. or Mrs. Breitweiser? So, thank you. Welcome.
Hello, Mr. Chairman and members of the committee. Thank you for letting me speak today. My name is Liz Youngman, and I'm the president of Students for Reproductive Rights at the University of Wyoming. We oppose this bill because we are curious as to why it is needed if the pregnancy centers are providing accurate medical information. And if these protections were to pass, I think I would be inclined to tell other students that these protections would be put in place for the pregnancy center that's in Laramie. So I've not heard of any attempts to restrict the pregnancy centers or the one in Laramie specifically. So we also think that this bill is unnecessary. Thank you.
Any questions for Ms. Youngman? Yes, Senator Cole, go ahead.
Yes. Thank you, Mr. Chairman. Well, good afternoon, Ms. Youngman. Just a question, what harm does this do? What harm would this do? I mean, what is the harm in this bill as you see it? If you could expound on that. Thank you, Mr. Chairman.
Ms. Youngman?
Yes, thank you. I think that it is, if the pregnancy centers are providing accurate medical information, I think it is strange then that these protections would be needed. And I think that people would question them and what they're trying to do. Thank you.
You think people would question who? Question the centers?
Yeah, the pregnancy center, yes, yes.
So the harm would be that they're questioned?
Well, these protections would imply that possibly they are doing something that is illegal or not providing accurate information to people.
But if they are, then the only harm would be that they're questioned, or I'm confused on what the harm is.
Well, I think.
If we pass this bill, it becomes law, and pregnancy centers, the state can't require a pregnancy center to do anything on this list, but they're not doing that anyway. What would be the harm?
I think that just in general, the fact that they would need these protections, it brings up the question of why they need these protections. Yes, thank you.
Any other questions? All right, thank you. Any other public testimony before I go online? All right, let's go to online, and we have Ms. Burke. Welcome.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, I'm Denise Burke, Senior Counsel with Alliance Defending Freedom. The Wyoming Pregnancy Center Autonomy and Rights of Expression Act protects Wyoming's pregnancy centers from discrimination simply because they do not offer, refer for, or counsel in favor of abortion, abortion-inducing drugs, or contraception. It does not, as some falsely contend, insulate pregnancy centers or their employees from appropriate regulation and oversight. It simply prevents them from being singled out because of their pro-life ethic. Wyoming's pregnancy centers are a critical and underappreciated resource that provides compassionate care and practical help to women and their families. Sadly, though, as has been previously mentioned, pregnancy centers are all too often being attacked rather than affirmed in their mission. The number of state and local government officials attacking the life-saving work of pregnancy centers has grown exponentially over the last few years as the legal and political landscape surrounding abortion has shifted. Notably, since 2022, at least 19 states have introduced measures attacking pregnancy centers' autonomy and life-affirming work. By comparison, in 2021, just 1 year prior to the Supreme Court decision overturning Roe v. Wade, only 2 states considered such measures. The goals of this bill are simple. It protects centers from discrimination. It ensures that they cannot be prohibited from providing pregnancy-related care, counseling services, or any other service related to pregnancy or postpartum care, simply because they do not perform, counsel in favor of, or provide referrals for abortion, abortion-inducing drugs, or contraception. It protects their rights of free expression and free association, rights guaranteed by both the U.S. and Wyoming constitutions, and rights that we have seen attacked in a number of other states. This bill allows Wyoming to be proactive in protecting this critical work and making sure that it's available to women and families in Wyoming, both now and in the future. Thank you.
Questions for Ms. Burke? Ms. Burke, I do have a couple of questions for you. Were you or was someone from your office a participant in drafting this legislation?
I worked with Representative Rodriguez-Williams on the language of this bill.
And the reason why I ask is this goes back to the conversation I had with Representative Rodriguez-Williams. I just want to make sure that our definitions align in statute. We already have a definition for abortion, so it seems that it could be a little dangerous in terms of how our laws work to provide a second definition that just at first glance does have some differences in it from our existing law. So I just want to make sure there wasn't some intent behind creating this new definition of abortion if we're okay to use the existing state law.
Mr. Chairman, it is certainly okay to use the existing state law, and there was no specific intent on using this particular definition. And many of as Representative Rodriguez-Williams stated, many of the parts line up nicely with the existing definition.
Okay. And as I'm just quickly trying to do as much research as I can while I'm sitting here, but going through the definitions, that's not the only definition that we run into some issues in terms of how it's already defined. So I think if I'm understanding the intent is not to create conflicting definitions. That if we have other conflicting definitions, we can rely on existing state law for those as well.
Mr. Chairman, there is no intent to create any conflicts in existing Wyoming law.
Okay, then we'll see what we can do. Any other questions for Ms. Burke? All right, thank you.
Thank you, sir.
Any other online testimony? All right, with that, I will close public testimony. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Kolb. Amendments, I would say we need to take a look at these definitions. The one that is most glaring to me is the definition of abortion, which I'm understanding to be 35-6-122AI. So I would entertain a motion to amend this bill to state that abortion means as defined, as it is defined in that statute.
So moved.
Okay. Pierre, are you tracking on page 5? Yes. Any discussion on that amendment? All those
And
in,
then the rest of the page gets deleted.
oh, yeah, I was just assuming that would make sense, but let's make sure, Pierre, that would delete all of page 5, lines 1 through 22 and replace with that sentence. Okay, all those in favor signify by saying aye.
Aye.
Any opposed? That amendment does carry. Senator Crago, you were looking at some of these definitions.
Yeah, so the other one that I think doubles up and is actually different is ectopic pregnancy. That's in same statute. So that would also be in 35-6-122A 5. So I guess we could, on page 6, line 17, ectopic pregnancy means as defined in 35-6-122A Romanet 5, which is from the good representative's previous bill, Life is a Human Right Act.
Okay. Any discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment does carry. Were there some other definitions in that previous legislation that we're using here?
Mr. Chairman, those are the only two that I saw that overlap. Now that there may be overlap with other existing statutes, so we may have to do some checking between now and as we move across the floor, but that's the only two that overlap in that particular statute or slash bill, excuse me.
Okay. That sounds good to me. Any other amendments to this bill, Senator Kolb?
No, Mr. Chairman,
Okay.
I just, a discussion about findings of fact, if we find that being valuable or not. I'm never a fan of, I don't care where it's at, the findings of fact seem pretty wordy to me, and I agree with the intent of this bill. I just wonder what good it really is there by doing this and putting more words in the green book. And I'd like to have a discussion from other members of this committee.
Those other members? It's hard when there's only 3 of us.
Yes, thank you, Mr. Chairman. So I've always been on that bandwagon. I'm not a fan of legislative findings either. I think our words speak for themselves. I mean, the intent of the bill is very clear. I don't think we need the findings, but I'm on the same page as you, or pages if you're talking pages 1 through 3, Mr. Chairman.
Thank you, Mr. Chairman.
I have a little bit of mixed feeling on it. I think that from a being disciplined in that we try to avoid it, and we're pretty consistent with that in the legislation that we have passed in the time that I've been here. We try to remain true to that principle. It's not a hard, fast rule that's, written down, prescribed to us anywhere. I agree with Senator Crago's legal analysis that this, when interpreting the statute, the words are gonna be what they are and what they say. So I think it does little to add to the actual intent of what the statute is. Although courts do look at legislative findings, they absolutely look at them. And it is part of their consideration and analysis. I can't tell you how much it influences their analysis. Senator Crago?
Mr. Chairman, I guess I'm not sure how much they actually look at them. They may look at them if there is some sort of vagueness within the statute and they're having a hard time, right? Rules of construction, if the words are clear, the words control. Only if those words are unclear do findings become important or even I'm not even sure important's the right word, relied upon or reviewed. In this statute, I don't really, this proposed statute, I don't see any issues with that. It's all pretty clear. We're saying this is what it is. We're prohibiting the government from interfering with pregnancy centers. That's the whole intent. And I think that's very, very clear. But, it's up for the committee to decide.
Yeah, Mr. Chairman, could we bring the sponsor of the bill up and ask the sponsor of the bill a more poignant question about the topic?
Representative Rodriguez Williams, I know we asked you how your feelings were on legislative findings, but it seems like there might be a push towards deleting the legislative findings from this bill. Your thoughts?
Thank you, Mr. Chairman, members of the committee. I would just push back. I think that I'd like to keep obviously I would like to keep the bill whole. I think as good Representative Crago stated that on page 2, there's pretty concise information as to what services are provided at these centers. And I guess my fear is if we take that out, whether or not there'd be some sort of abuse of the name and the title, can anybody call themselves a pregnancy center and fall under this? So looking at like the services provided that are
Well, Representative,
within these findings.
sorry, Representative.
Yeah,
The
Mr. Chairman.
Pregnancy center is defined on page 7. And so if as long as that definition is sufficient and tight, then I would hope that would not be a problem. Senator Crago?
Quick question, totally unrelated, and I got to this as I too was reviewing the definition of pregnancy center, and it says private nonprofit. Is the nonprofit part necessary? I mean, could it be any private organization that's providing these services? I mean, just throwing that out there, a question for you as the sponsor, do we want to restrict it to only nonprofits, or would we want it to apply to any entity that's providing these services?
Representative?
Mr. Chairman, Senator Crago, the intent of the bill is really to narrow it down. And it is Wyoming specific. I would tell you that, there are a little under a dozen of these spread throughout the state. My hope is that the bill stay whole. It aligns, I guess, I would say, with the majority of support from the body, that it remain narrow with the nonprofits. But again, a policy decision of your committee.
Yeah, my only concern is, looking at the number one thing that the state or its actors cannot do is require a pregnancy center to offer or perform an abortion. So that's the number one thing it cannot do. And if there happens to be a private organization that is a pregnancy center, then they could be required to do that by the state. I don't know all of the centers in Wyoming, so I don't know if they are all are nonprofits or if that's just the model, they're always gonna be nonprofit, so it doesn't matter. But it seems to me that with Senator Craigos' question, to broaden the definition of pregnancy center would actually do more to protect pregnancy centers. It wouldn't harm them. That's at least my reading of it. Representative Rodriguez Williams.
Mr. Chairman, members of the committee, you're entitled, to your opinion. I have mine. I would just, again, just push back and just ask that the bill remain a little more narrowly focused. But again, I respect the wish of, or the desire of the committee if they choose to get outside of the scope of the bill.
Senator Crago.
Thank you, Mr. Chairman. So I mean, I think the chairman and I are on the same page. We're trying to make it apply, provide more protections. I guess my question, and we don't have to answer this today, and maybe you could get back to us, is there a reason we're limiting it to nonprofits versus any entity that might be providing these services? Is there a legal ramification to that? I'm just trying to wrap my head around it, because it seems like you'd want it to be as broad as possible if we're trying to prevent government interference. So that's all, I think that's where we're trying to go, and doesn't have to be answered today, but sure could use some advice on that later.
Representative Rodriguez Williams.
Mr. Chairman, Senator Crago, I think it just goes back to historically what I explained that's happening to these centers across the nation, and taking a specific preventative move in Wyoming. So this bill basically addresses what the landscape of Wyoming looks like when it comes to these centers that are in place and providing services within Wyoming and having an impact on our communities. I don't know whether or not expansion of the language is needed. I think it kind of muddies the water a little bit, but it's definitely a conversation to have. Maybe something we can look at down the road, maybe next session in amending it if the need was there. But again, I think the bill accurately reflects what centers are here in Wyoming and their services specific to Wyoming.
Senator Kolb.
Yeah, Mr.
You
Chairman.
probably want to go back to legislative findings.
Well, no, I like the pregnancy center question now. And
Okay.
it's in the bill title. It says pregnancy centers. So in respect to the conversation about the question, it's to make it a more broad, to cover more entities. I see it as an improvement because it covers it more broadly. And right in your bill title doesn't specify anything but pregnancy centers. So it seems like it would fit a little better, and it makes it a wider net to protect these type of operations. And I see it as a positive thing. That's why I promote it. I mean, not a negative thing. And I think it helps your bill it helps the bill do more things.
Representative Rodriguez Williams.
Mr. Chairman, Senator Kolb, I respect your opinion and just stick to the wholeness of the bill as my response. Thank you.
So I don't know what's going to happen, but let's assume that maybe we amend that to make it broader. We'll have obviously three readings that it can go through on the Senate side. So if we take that action and you do some research and find out that it's problematic, let us know. I think all three of us are on the same page. We're trying to help the bill, not trying to hurt the bill, trying to cast the net as wide as we can to help as many of these centers as we can. So, okay. We're actually on amendments. Any amendments? Senator Kolb?
Yeah, Mr. Chairman, I don't know where other places it might be applicable, but page 7, line 2, strike nonprofit in this private organization that promotes childbirth, to widen it up, and actually it meshes with the bill title a little more closely. And I propose that as an amendment.
We've already had the discussion. All those in favor signify by saying aye.
Aye.
Any opposed? Okay. Other amendments or discussion on this bill? Are you satisfied with your discussion on legislative findings?
I'll hang my hat on the pregnancy centers, Mr. Chairman,
Okay,
and I'll be satisfied with that.
okay. We're just trying to look at as many of these definitions as we can. And I think that's it, so hopefully we got them. Okay. Any discussion? Senator Craigo?
Thank you, Mr. Chairman. I guess, and we may just have to cross-reference this with some of the other bills we got moving through the pipeline. That might be our other question on definitions, because we got several of these bills, on both sides of the hall. We just, as we move through the floor, we just need to probably keep an eye on that and make sure they're all coordinated and have the same language.
Make sure they're all talking to each other in the right way. Okay. Pierre, will you please do a roll call vote on House Bill 273?
Senator Craigo,
Aye.
Senator Crum,
Excused.
Senator Higgs,
Excused.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
3 ayes, 2 pass amended.
Representative, just so I know when this bill comes up, do you know who's presenting it? Do you have a preference, or are you gonna still have to get with your co-sponsors? Do you know? Okay, all right. It's just helpful so I can call on them and not be taken off guard. So they just tell them to let me know or something like that. Okay, thank you, Representative. All right. The next bill for our consideration is House Bill 324, State Elected Officials, Employees at Will Regulations. I saw Representative Andrew outside. Okay. Welcome, Representative, to Senate Judiciary. We are ready for House Bill 324.
Thank you, Mr. Chairman. Sorry for the delay. Mr. Chairman, I bring you House Bill 324. Wyoming is an at-will employment state. The chief executive staff are at will. Our legislative staff are at will, and the judicial branch operates under at-will employment as well. Yet, our independently elected statewide officials, the Secretary of State, the state auditor, the state treasurer, and the superintendent of public instruction are still bound by bureaucratic structures that hinder their ability to govern efficiently and effectively. House Bill 324 corrects this inconsistency. It allows elected officials to quickly build a team that aligns with their vision and goals that the voters elected them to carry out. They have the ability to hire qualified staff. They must, sorry, I somehow ran out of breath running across the hallway, but happens to you when you're sitting at these desks all day, Mr. Chairman. They must have the ability to hire qualified staff and make necessary changes when employees are not aligned with their mission. This bill also frees elected officials from restrictive HR policies and procedures that are not designed for the unique needs of these offices. Under the current system, making even basic staffing adjustments, such as modifying positions, classifications, adjusting salaries, or addressing performance issues, can take months. This type of red tape prevents government from operating at its best. If we expect top-tier performance from these offices, we must give them the flexibility to reward high performers, make quick staffing decisions, and respond in real time to the demands of their work. This bill does not give elected officials unlimited spending authority or unchecked power over hiring and salaries. The legislature will continue to maintain full oversight over the budget and the number of positions authorized for each office. House Bill 324 does not change that. What it does change is how effectively and efficiently these officials can manage their own offices within the appropriations set by the body. This is a common sense reform and gives our statewide elected officials the flexibility to lead effectively. And essentially, what this bill does, Mr. Chairman, is it takes the language from the statute that governs the LSO and applies it to the staff of the 4 statewide elected officials. Thank you.
I wasn't sure if you were just catching your breath or if you were done.
No, I finally caught up, so.
Okay. Can you walk us through the bill?
Yes, Mr. Chairman. So essentially, as I was saying before, it takes the rules that apply to the LSO and applies to these agencies. So they would set up their own policies for HR practices in the same way that many other entities that hire people do, and a private employer. It doesn't add a lot of restrictions, but it does require them to establish those policies. And then it also has in section 2 a provision that says that nothing in this act shall be construed to alter, amend, or impair any agreement or contract entered onto before July 1st, 2025. And that is important because this bill looks forward and does not backtrack on any of the contracts that may be in place now.
Do we know how many contracts would be affected by this legislation or would not be affected under section 2?
Mr. Chairman, I believe that would essentially be around 200, because it would be the total amount of employees that exist in those agencies and the permanent status that they currently have. And additionally, Mr. Chairman, if I may, to staff this move, we borrow from unfilled positions from the Department of A&I and give 2 full-time HR positions to the auditor's office. And all 4 agencies would share those 2 positions to handle the staffing needs of those agencies. And there is language in this bill as well that specifies that dealings between each agency and those HR professionals should remain private between those professionals and the agency that they are dealing with.
Committee questions for Representative Andrew? Senator Craigo?
Thank you, Mr. Chairman. You said it was copied from a different statute? Or the language is effectively copied. What's the citation on that, Representative? Mr. Chairman, sorry.
Yes, Representative Andrew.
Thank you, Mr. Chairman. I unfortunately do not have that with me. It was the statute that governs the HR policies of the Legislative Service Office. I'm sure we could figure that out during public testimony.
Okay, Senator Kolb.
Yeah, thank you, Mr. Chairman. Representative, just a question. Do you have the total number of, at-will and for-cause employees that are currently underneath these different departments or elected officials? So we can kind of get a feeling on what we're talking about. And if they're for cause, what's the plan on trying to compensate them for, frankly, changing their employment from for cause to at will? You know, have we contemplated any compensation for that, or is there any? I mean, just your thoughts on that in general. Thank you, Mr. Chairman.
Representative Andrew.
Thank you, Mr. Chairman. So there's about a total of approximately 200 employees in these 4 agencies. Usually between 3 and 7 of the employees that are directly under the executive are at will. The rest of them would be permanent employees. And we did not discuss the compensation because this bill works going forward. It doesn't retract those permanent statuses. It protects the contracts that are already in place.
Senator Kolb.
Yeah, thank you, Mr. Chairman. So this is it only apply to future agreements for new employees. Is that correct? Thank you, Mr. Chairman.
Representative Andrew nodding his head.
Mr. Chairman, yes.
Senator Craigo.
Thank you, Mr. Chairman. So just one more question. Why not include all of the statewide electeds, all 5? Is the governor's office employees treated differently, or why are we segregating that office out from these 4?
Representative Andrew.
Mr. Chairman, Representative Craigo, simply because the governor is in control of the policies through his appointments that apply to his office. So the Department of A&I that sets those policies are, that is an appointed agency. And so everything that doesn't have a statewide elected executive is under the purview of the governor.
Senator Craigo.
Mr. Chairman, so just follow up. So does the governor have employees that are all of the governor's employees at will, all however many hundreds, thousands of them, or not?
Representative Andrew.
Mr. Chairman, Representative Craigo, I'm sorry, I understand now. Yes, the employees who work in the governor's office are at will. Everyone who is in a different state agency that has an appointed executive are not at will. And the reason we contemplated just changing these 4 agencies was because of the elected status of the executive.
Senator Craigo.
Thank you, Mr. Chairman. I'm just struggling with why, if we're gonna do these 4, why not do all 5? Why not give the chief executive the same opportunity that we're by proposing to give to the other 4? I mean, we're just segregating out that particular statewide elected. And so if you could help me on that, why not include that? There's portions of this bill I can understand why we're segregating out, but the part about at-will employees I'm struggling with.
Representative Andrew.
Mr. Chairman, Senator Craigo, that's certainly something we could contemplate as well. I decided to start with a smaller bill, and I thought that the elected status was a good way to differentiate what we could start with. I think that, it would be something that I would be open to discussing as well, but that's just not what we started with.
Other questions for Representative Andrew? All right. That's it. We'll move into testimony. Thank you. You're gonna stick around?
Yeah.
Do you have committee right now?
I do, Mr. Chairman, but if you
Go
need me
one
to
more.
stick around, I'd be happy to.
I mean, I don't think so. It's totally up to you. If we have a burning question that we need from you, we can always message you to come down it's up to you.
All right, thank you, Mr. Chairman. Yeah, send me a message and I'll come back over.
Okay. All right. Any government agencies wishing to testify on this bill? I see a couple. Welcome, Superintendent.
Thank you, Mr. Chairman, members of the committee. 2 weeks to be in Judiciary Committee is quite a treat, so good to be here. Just offering to speak on this bill as it directly impacts my agency. I come straight from the private sector, so I'm always in favor of ways that we can make state government more in line with the private sector. I think it's never a bad idea to be able to provide our duly elected officials with the autonomy to be able to do their jobs and be more responsive to our voters. I think looking at the bill, it really is about three things, and that's the at-will status, the ability to not be under some of those HRD rules and procedures, and then three, the decentralization of HR staffs back to the electeds. So I would encourage to look at those three things. The four electeds that are impacted by this bill, we did meet, discussed possible amendments and versions that we could be happy with, and so would also entertain my colleagues to be able to share as well. And with that, would keep it short, but would answer any questions.
It's just you, Senator Grego.
Mr. Chairman, I talked to the good superintendent prior to this meeting.
You had
so
all your questions
I
answered?
did. We had a good chat. Thank you, Mr.
Okay.
Chairman.
All right. Thank you, Superintendent. Auditor Racinas and Treasurer Meyer. It is, we're struggling to keep a quorum here. It's not our usual day to meet. We are meeting outside of our regular time because we have a lot of bills in our committee that we're trying to get through.
Mr. Chairman, I have heard from other members of my household that you meet a lot outside your regular time. Mr. Chairman,
Yes.
I'm mostly here to answer questions. I don't have terribly strong feelings on the bill. I think the at-will portion is admittedly what I care about the least. In my office, to Senator Crago's earlier, or maybe it was Senator Culp's question, I'm the smallest of the electeds. I have 23 folks, including myself. 6 of those, when you include myself, are at will. I do not intend to let myself go. Being honest, everybody that needs to be at will in my office already is. So the proposed amendment that would allow the elected to determine whether a position is at will would be preferable as opposed to saying all of your positions are at will. While I think we do have and need that in some of the higher positions, sometimes as you know, and I'm guessing you'll hear that at will designation, especially for some of the lower paid positions, can make them tougher to fill as opposed to easier. So again, Mr. Chairman, I'm mainly here to answer questions in regards to, potential amendments that might come up and how we feel about that.
Committee, questions for the auditor? All right, we'll see if we develop any, but so far none. Welcome, Treasurer Meyer.
It's good to be here, and Deputy Treasurer Williams and I will kind of tag team some of these things. From my perspective, I think I can echo the sentiment of the auditor that the at-will positions that we have now probably fit the bill. Deputy Williams can tell you exactly how many that is. But there is, and it did take us probably all of the first 4 years with the process that we have now as far as, making sure that, we protected the employees' rights at the same time, making sure that we had people that could do the job. It probably took us a year to get to the point where we feel now that every position that we have, and with doing skills tests with the individuals that we do hire, so we know that they can do the job, we're set pretty good. And I have more of a concern, when I time out of this position and the next person comes in, of basically upsetting the apple cart with carte blanche at-will status for a good number of people as this, I guess, moves through the processes. In fact, talking to a consultant who's a headhunter for our chief investment officer, one of the things that some states are doing, even on their at-will positions in political circumstances, that they'll add a protection period of 6 to 18 months on certain positions that are really deemed kind of critical. I would really hate to see somebody come in and fire our complete, basically investment staff. That would be a travesty. It really would, because they're doing a great job. And so I would like to make sure that either by regulation in our office, that we put some protection in for those people that are really critical, as well as probably the top 4 or 5 people in our accounting department that are extremely, extremely critical, and our attorneys who have really subject matter expertise that it took us well over, darn near 2 years to fill one attorney position. And so I can't see, anything good coming out of having total at-will and no type of protection at all in those folks. So now the one part that I could say that would really, 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 really help is some flexibility that you had that's in this bill to actually be able to determine what our employees do and how they're posted, and that they're posted in a timely manner. There are some things that are going on now that we're barely paying our attorneys enough to keep them around. And the deputy can go into those circumstances, I think, in a little more detail. And then just looking at the things that happen in a day-to-day circumstances where we don't get timely participation with the HR people. I know I heard that there was less than a month on average. I can tell you that that's, in our particular circumstances, it's a lot more than a month on bringing in new people. And I think the deputy can go into some detail on those if you want to hear those things. There's a lot of horror stories that I could tell you. I don't think this is the appropriate place for me to share those, specifically. But I think the deputy has some details that in a statement that she'd like to read now.
Treasurer, I just have one quick question for you, and I apologize if you already said this and I missed it, but you've seen the proposed language of the amendment?
Yeah.
And do you prefer the amendment to the language in the bill?
Well, I haven't seen I think the proposed amendment, if I recall, is that we're going to have some more independence with individuals within our office to do our HR.
Yeah, the state official would have complete discretion over whether to make them.
Yeah, I think that would be much more functional in our circumstances. The one thing that, if we're going to get to running these offices as a business, and I can tell you from our perspective, is that we have to have legislative authority on the appropriation of the amount of money spent in our businesses, or we'll lose things like immunity and other things that we would have, in our investment portfolio. And so we have to have that. But one thing we don't need to have is, I would say, direct oversight by an executive branch and in essentially also the legislative process about how many people we have and what we're going to pay them and what they're going to do. I mean, it's like running a business with one hand tied behind your back, or even both hands tied behind your back and your leg up to your belt and hopping, because there's things that really keep us from implementing the most effective, efficient business enterprise. And we are a business enterprise. I would say we're the largest investment operation in the state of Wyoming. But we can't really tell people what we have to pay them, and we can't tell them what they have to do. Now, anecdotal thing on this is when we were trying to hire some people, the previous deputy from the treasurer's office and the governor's, then the current deputy, she said, "Don't worry about it, Kurt, just hire them and tell them to do whatever you want them to do." But essentially, I'd be, from my perspective, I'd almost be breaking the law or the intent of the law. And I felt very uncomfortable doing that, where you advertise something entirely different when somebody comes there, and the only thing you have is, or other duties as defined by the treasurer. Well, if they're not in the posting and you hire somebody and you ask them to do something else, then essentially you start getting a little pushback right away from the employee you just put in the seat. So basically having authority to tell these folks that what they're going to do and how much we can pay them and how many employees, because we've got, I think, 49 now. It might be that we'd rather have, 52, but not pay any more money. Or maybe we'd rather have 45 and be able to hire that one person that for another $8,000, we could have got someone that just perfectly fit the bill. But there's just no way on God's green earth that we're going to be able to hire somebody for what we can pay them. Thank you.
Go ahead.
Thank you. I'm Dawn Williams, Deputy State Treasurer. The Treasurer did ask me to give you a couple of examples of why the concept of this bill is important so that you have some concrete examples. So the first one is regarding our attorney positions. I've been trying to reclassify them to a certain level since 2023. I was denied and told in September 23 there would be an occupational study for the attorney classification, and I should just wait until the HRD could do a deeper dive. Any further classification changes need to be associated with that study. Nonetheless, I requested a reclassification again in May of 2024 based on the needs in my office. I was advised that they would not be entertaining any individual classification review until the study commenced in August of 2024. Well, we had our first meeting for that classification study in January of 2025. After that meeting, it was clear to me that we're not going to be done with this study until next year, later this summer, probably not till January of 2026. So if I even wait till this summer, it will have been 2 years since the first time I asked for a reclassification of that position according to the needs in our office before I will even have it considered, and then it could be denied. Recently, HRD completed phase 3 of the compensation adjustments. Those adjustments were explained to us to relieve compression issues. As I reviewed, I got a list after the fact of who in our office would be eligible for these adjustments to their pay. I identified and looked and I said, this isn't going to relieve compression for these people. These are going to cause compression on some of these people. Well, Dawn, your definition of compression is totally correct. However, if we in HRD had to measure how the knowledge and skills and experience or abilities of these people, that would be subjective, and we just need a way to do this that's across the board. I said, how about contacting the agencies themselves, the directors, the people who are actually responsible for these folks to determine whether or not there's compression issues? How about consulting us? That is not an option with the way that things are done right now. So, Mr. Chairman, those are just 2 concrete examples, recent examples that we can give you why this is so important to us. We would advocate to do, as the superintendent suggested, to return to the way it was previous to the consolidation as far as having our own employees embedded in our office, and then to be able to as this bill suggests, to create our own policies and procedures so that we are able to accommodate some of these needs. Right now, the treasurer talked about how obviously we'd love to have our own budget and have and handle our business that way, but that's not what this bill contemplates. Right now, we're just contemplating being able to classify our positions according to our needs and to come to you, the legislature, and say, hey, this is what we've determined that we need in our office, and have you either approve or deny the funding. That's the relationship that we wish we would have. So thank you, Mr. Chairman.
Mr. Chairman, I'd like to maybe give some color to a question that you asked, why not the governor's office? If that would be okay.
Yeah, please proceed.
The simple reason is that the governor is in total control of his own destiny, because the HR office is in A&I underneath his total control. And if he wants to onboard employees in a timely manner with the exact job description that he wants, he's under total control of that. We would like to have that same ability, to have that control. And also, he's got enough positions that he can be 11 positions in money, any place within thousands of people within his agencies. We don't have that control, so we have no flexibility about how many people should be in the accounting department, in the unclaimed properties department, in the legal department, in our investment department. We don't have that capability because we don't have access to that state agency pool of people. And as I'll go back and say, is that you guys got to tell us how much money we can spend, and because we have to go through the appropriations process, because if we don't, we get penalized and penalized severely in our investment operation.
Senator Crago?
Thank you, Mr. Chairman, and not really a question. I was just going to acknowledge the treasurer's comment. And really, I was talking about the part applying to at-will employees. I totally understand the rest of the bill and why that language is in there. If we're going to make your employees at-will, why not the governor's office too? That was my question for the sponsor, but I totally understand your sentiment. Thank you.
And to make it absolutely clear, we are not in favor of the at-will positions, the at-will positions within the bill. It does us no good, and as I said, to the contrary, I'd like to be able to, and I think I can perhaps by rule, to add a little bit of protection on the way out the door so we don't have a clean sweep. I don't want to interfere with the next person coming in, but I do want to make sure that we don't have Billy Bob, Julie Jane, and everybody else that wants to come in on somebody's coattails wreak havoc with an agency that is starting to reach its potential.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Well, this brings me back to the days when I was a county commissioner, and I can't tell you how much identical conversations we're talking about elected positions and the folks you have underneath you. So really the question that came down to this is that there are people underneath you as electeds that are specialty people. Maybe they're investment folks, but there's other people that are mundane, the secretary folks and the people that are doing, pushing paper, for lack of a better word. And without uniformity between those divisions, you get poaching, you get people leaving one group to another group. So there is a problem. I think there's just two different divisions. There's specialty employment positions, and then there's people that are more mundane. That's one thing. And then to the point you brought up about you want to protect your people. Well, I can't tell you how many times I've heard that over the years with an elected official that says the exact same thing because they're happy with their people, because they've changed them out over the years and they want to protect them. Yeah, well, there's nothing new there. So I still want to know why the at-will position, because just like when you came into office, my question would be, is you found people that are adversarial to you. Maybe they ran against you, I don't know. But it was a situation where you just couldn't get along, or you didn't feel as the elected official was just elected, you couldn't get along. Why wouldn't you have the right to deal with that person? Why would that person be protected and you have to put up with that as the newly elected person? Let's just say you were in that circumstance. So how would you justify what you just said when you had a situation like I just tried to explain? What would you do,
Yeah.
Treasurer Myers?
Treasurer Meyer.
Well, what I did, I basically had some people that necessarily, I recall one higher level official, he said, you know, Kurt, I've had 6 people tell me that you're going to fire me within a week that you get here. You know, and I just looked at their performance and I knew that their performance was acceptable. And I can get along with people because I think a lot of it, because I was in the legislature, you just have to figure out how to get along with people you disagree with because you're going to disagree with them, you know, and so I had that background experience. As far as the 6 month, I think that's a reasonable time period because it will take you 6 months to get rid of somebody for cause because of the structure that's in this, your regular person there. And that is basically because you have to go through this process where you have to try retraining them. You have to go into process of whether you can put them in another position that's not as taxing, you know, and you try everything you can to make sure that that person has that opportunity. That takes about 6 months to work through that. So when I look at moving out of my office and having someone else come in, I think that 6 month time period is reasonable for them to understand whether or not the person, you know, can actually work with them. And they could probably get around their I don't know, philosophical or principled distaste for each other. But after that 6 month period, you know, then it's like Katie bar the door and what do we got? 19 at-will people, I think, Don? 15? 16 at-will people. Most of those are in the areas of the investment team. So, you know, as far as poaching, I thought that's a reasonable thing because a lot of times there's people in other agencies that are fine. But I think what I found out more often than not is that when a person from another agency comes to us and the head guy says, oh, you're taking my best person, you don't hire them because they actually turn the table on you and you don't get who you think you're going to have. But most of the people that we're poaching is here, especially in accounting, actually came from the Midwest because at one point in time we had about $5,000 more pay scale than what people in the Midwest were paying for that. That has changed. We're still trying to find that sweet spot of we just have one person to fill in our accounting position, but some of those took a long time. The real hard time is when you're dealing directly with I'd say in the attorney position because you're dealing directly in private competition, not only here but across the country for attorneys. And most attorneys make a lot more than we can pay them. So it's really variable as far as, you know, what position and what kind of employee are you trying to get as to whether or not you can do them. To the point of your specifically on your person, the receptionist, that's relatively low paid job. And so you can usually find those folks through a temp agency or something to get by with. And a lot of times you just hire the temp if they're doing a good job.
Other questions, committee? All right, thank you. We have Secretary of State's office and the governor's office. You can come, why don't you come on up? We'll just start with the secretary's office and then we'll go to the governor's. And then we'll go to A&I. Welcome.
Good afternoon, Mr. Chairman. My name's Jesse Naaman. I'm the Deputy Secretary of State. Our office has been monitoring this bill as it's progressed through the legislative process. The big thing we want to emphasize is if it goes through, it's important that we have the resources to implement this bill. We've been in conversation with the auditor's office, the treasurer's office, and the superintendent's office, and in order to implement this and subsume the duties of A&I, our office would need adequate resources. Secretary of State's office specifically would need a full-time HR person. I understand the other elected deputies, we talked about doing an amendment. I don't know if you've been provided a copy of this amendment or not, but we just want to express general support for making sure we have the resources to get the job done.
I do not believe we have that amendment.
I was not aware, but thank you. I don't have a copy unfortunately, but I'm not sure what we're going to do with that. I just want to make sure
But
to,
your amendment is to add an HR position to each department?
what we would want to see would include, at least our department, we would want our own. And then there would, of course, be a corresponding appropriation to go with that if it were to be seen.
Do you have an understanding of what the appropriation would be?
I would have to, I'd have to double check that.
Okay. All right. Very good. All right, let's go to the governor's office.
Good morning, Mr. Chairman, members of the committee. My name is Betsy Anderson. I'm the Deputy Chief of Staff and General Counsel for Governor Gordon. So the governor is not in favor of House Bill 324. There's a lot that can be said about this, so I will try to move quickly. If you have questions during my testimony and want to stop me, please do so. There are basically two parts to the bill, as you've identified. First is the exemption of the 4 elected offices from the personnel rules. And the second is the mandate that all of the personnel and elected offices would be at will. So I'd first like to address the matter of the exemption for the personnel rules. I do want to make clear, since there was some confusing comments in the other house, that the employees in the governor's office are required to abide by the personnel rules. The governor's office is not exempt from these rules. We have classifications and compensation pay bands. And I do ask, why would you not want to have all state employees live by these rules, such as leave policies for jury duty, FMLA and military leave, performance reviews, equal employment opportunity policy, discrimination, employment of non-US citizens, conflicts of interest, et cetera. That is just a very small list of the many topics that are covered in the personnel rules. I do recognize that some provisions in the personnel rules are different for at-will employees, such as those in the governor's office. But that is a distinction for all at-will employees, no matter what agency they work for, including the current at-will employees in the 4 elected offices. Yes, the LSO has its own personnel rules for its staff, as does the judicial branch. But this is a separation of powers issue, and each of the 3 branches governs its own personnel. To have 2, and I don't know how the bill is to be read, but possibly up to 5 different sets of personnel rules for the executive branch doesn't make sense. I would also like to point out, importantly, that the personnel rules for the executive branch are subject to the Administrative Procedures Act and are thus posted for comment and reviewed by your management council before being signed by the governor. I didn't see any provision that the personnel rules adopted by the 4 electeds would be subject to the same scrutiny. I understand from the treasurer's testimony that, and I think for all the testimony of the electeds, is one of the parts of the personnel rules that brings them the most angst would be the compensation. And they do feel this need that from time to time they want to have higher compensation for their employees. But I'd like to point out that, the governor is responsible for the budget for the entire executive branch. And so we do have concerns about, as you mentioned, poaching, but also the idea that, each elected is responsible for their own agency. And without thinking about the impact of trying to be fairness and the appropriate amount and market rates across all state executive employees, that makes that decision a little bit different. And so that's why we feel it's very important that a compensation policy is followed by all branches of the executive agency, all agencies of the executive branch. Then I'd like to talk about the second topic, which is the at-will employees. Yes, everyone in the governor's office is at will, but when you look at the duties and responsibilities of each of the elected offices, you can see reasons why this is the case. I recognize that the electeds have important policy roles to play for their agencies and the state. But unlike the governor, the other electeds also have direct administrative responsibilities. The Secretary of State handles elections and business. These are just samples, not everything, but they handle elections and business filings. The auditor handles the annual financial report and payments for employees and vendors. The treasurer invests state funds, disperses funds, and handles unclaimed property. The superintendent has an incredibly long list of responsibilities for distribution of federal funds, administration of federal programs, administrative state programs such as standards and assessments, data collection and reporting. I mean, this is just to name a few. They have a lot of direct responsibilities. These responsibilities are very complex, and there are extensive statutory requirements that must be complied with. So institutional knowledge is critical. For example, it's hard to imagine that if a new treasurer were to decide to release all of his or her employees who handle the back office implementation of the $30 billion in investments, which are quite complex, there would not be a significant risk of material mistakes and statutory violations. The same would be true for elections or the financial reporting or any of the education programs. You might say that the governor's office loses all that institutional knowledge with each administration. But the governor's office doesn't really implement programs. The 45 agencies under the governor's management handle the day-to-day administration of government programs and services. And these agencies have thousands of permanent employees who are hardworking and dedicated with extensive institutional knowledge, without which the state would suffer greatly. A new governor does not have the authority to terminate these permanent employees throughout state agencies. So these responsibilities of the four electeds are what distinguish them from the governor's office and why making all of their employees at will creates a risk for the state. I would also note that their deputies and senior leadership are currently at will, and the electeds do have the ability to change those personnel without cause. There's two aspects of at will employment I'd like to address. First is recruitment and retention. And we hear testimony that a new elected could come in and fire all the employees in the agency. You lose all that institutional knowledge. But I don't see that as the most likely scenario. What I worry about is when an elected decides not to run for re-election. Once the May filing period passes, and it is clear that they are not seeking re-election, many employees will move to other agencies. They will not wait for the new elected to take office, as they will not know who that person will be and if that person will retain them if they are at will. It is incredibly stressful when you have a mortgage to pay, tuition bills to pay, a new baby, or whatever is going on in your life, or just putting food on the table when you have to wait and see what a new official will do, and you are sitting there and you are at will. And of course, hiring people during this time period is very difficult as well because of the uncertainty surrounding who the new boss will be and if they will clean house. So performing the functions of these offices, such as elections and the ACFR, during this period of uncertainty will be challenging as people leave and you are not able to replace them. And then the other issue I'd like to address is cost. I know there is no appropriation with the bill, but at some point, the electeds will have to come back for more money, as you must pay at-will employees more than permanent ones. For example, I think has already been mentioned, you cannot change a permanent employee's position to at-will without paying them a higher salary, and then you can only do so if the employee agrees, which is why typically you wait till an employee leaves that office, and then you change that position to at-will when the new person comes in. And to explain the extra costs, another example I'd give is the administrative staff in the governor's office and the positions such as the governor's EA and the office receptionist. In other agencies, these would be permanent positions, but because they're in the governor's office, they're at will. We cannot pay these employees the same as their permanent counterparts in other agencies because they do not have the same property right in their position. There is an inherent risk in their at-will status, and so we have to pay them more. And so making these approximately 200 employees at will certainly grows the cost of state government, not with the number of positions, but by ever-increasing salaries due to their at-will status and the elected's ability to determine salaries without any adherence to classifications and pay bands that are designed to reflect market rates and to create fairness among the agencies. I do understand that they will be limited by the total dollar amount of their 100 series, but I would anticipate they will ask for increases as time goes on. There's been testimony that HRD is difficult, and I worry that difficult really means that HRD will not let people do things which do not comply with the rules. I know that following the rules can be hard, but they are not arbitrary. Each rule is in place for a reason and serves a purpose. We in the governor's office also get frustrated with some of the rules from time to time, but we understand their importance and do not believe it means that we should be treated special or different. In conclusion, the governor does not support the bill as it grows the cost of government and it jeopardizes the proper performance of the duties and responsibility of each elected's office, since it greatly jeopardizes the recruitment and retention of institutional knowledge that is essential for the electeds to perform the duties of their offices. I'd also like to address some of the comments about the flexibility and number of FTEs and salaries. Obviously, number of FTEs is not addressed in this bill. That is something that's done in the budget bill through the legislature. And so that type of flexibility is not something that you would find here. I also know, because I did listen to some of the debate on the other side, there was talk about wanting to reward employees. I don't know what that means. We always think of a bonus system as what you go to, and maybe that's not what's meant by that comment. But that's not something that I do think the legislature plays a role. We have one performance compensation program, I think, right now in state government, and that has been approved to the legislature. So certainly, if we're going to do something like that, we would want to include the governor's office and all approximately 7,500 employees that work under his administration. So with that, I'm happy to stand for any questions. And I know that Director Bach has some detailed information about some of the compensation classification requests they've had.
Any questions for Ms. Anderson? Yes, Senator Kolb.
Yeah, thank you, Mr. Chairman. Good afternoon. Just to, I find these conversations really the same everywhere. So the consequence of having an elected government, having elected positions are in fact leading to this at-will question. Why is it all right that, they have to live underneath a for cause situation in an elected office when they get elected? Why is that the right thing to do? I mean, the cost of government is always more with an elected position. It comes with the territory because of the newly elected. So why would you, I mean, I heard your argument, but why would you deny a newly elected person the ability, to make a selection in their office for their personnel, be it the treasurer, whomever's office it is? But I mean, barring the fiscal costs, which probably will be more, why shouldn't they have the ability to make a choice to run their office as they just got elected? Why shouldn't they? I guess what's your response to that question? Thank you, Madam
Ms. Anderson.
Mr. Chairman, Senator Kolb, I don't know that I have anything to add to my comments. I do think that, as I said, the electeds play a very important policy role. I mean, their work on the various boards they're on really are important to all Wyoming residents and are not necessarily related to the subject matter of their role: Secretary of State, elections, treasurer, investments. But unlike the governor's office, they have to perform those responsibilities. And I can tell you, in the treasurer's office, is way more complex than anybody realizes. I worked there for 15 years. And I think it's got to be true for the ACFR, and it's got to be true for, these education programs, especially when you're looking at dealing with federal funds, the requirements have to be incredibly complex. Elections, how important are they to the state? And so they actually have those direct responsibilities. And it is important that they're done well. And to throw out all that institutional knowledge, I worry that you really are setting up the state for a very difficult situation where they are not going to be performed those statutory duties and responsibilities. So that's.
Senator Kolb, follow up.
Yeah, just follow up, Mr. Chairman. I understand that. That wasn't my question. question is, we have a situation where you have an adversarial employee in an office, and then you're caught in a situation where you can't deal with that. That's my question. You have a person in an office that's not performing, let's say it's a political difference. What do you do with that said person? I'm not talking about the extreme case of, getting rid of folks that are critical for the day-to-day mundane activities, but when you have a newly elected person and you have someone in the office that frankly you can't do much with without them being at will, what do you do with that person? How do you mitigate somebody you're stuck with? I mean, that's my question to you. Thank you for your answer.
Ms. Anderson?
Mr. Chairman, Senator Kolb, that's where you would talk with A&I and your HR representative and go through the process of grievances. If you just have a political difference, but that person's still performing their responsibilities, they're not creating or part of a hostile or toxic work environment, yes, they will have all those protections but there are for cause reasons that you can terminate a permanent employee. And you can work through the steps with HR to help you figure out how to get to that point where you can actually terminate them. But because you're right, because of the permanent rights, it's not something you could do at the flip of a switch. You would have to go through the process.
All right, thank you. Let's go to A&I.
Thank you, Chairman Olson. My name is Patricia Bach. Excuse me. I'm the Director of A&I, which also covers HRD, which has been a little bit of a topic today. First, I would like to try to answer Senator Kolb's initial question, and I think I understand where you're coming from. For example, the Treasurer's Office is 43% at will, so almost half and half. The majority of times when you come in, or they come in as an elected official, those are the folks that they're bringing to the table, the people around them, the investments, and most of those people stay on as well for the next. But if you have a situation where you have a permanent employee down the ranks that's causing a problem with the treasurer, the secretary of state, the auditor, that's something that's easily dealt with. And the problem is you have to stay on it. And you have to have an HR person who knows the rules and goes through that process, which is HRD. So I would say that it is something you can deal with. It is not flipping a switch, but it doesn't mean it can't happen fairly quickly, especially in an elected's office. And we take that seriously when they have an issue like that. One thing I wanted to discuss, I'm going to kind of skirt by the at-will.
Hey, Director.
Yes.
Can I ask you?
Sure.
That statistic you just threw out for the treasurer's office?
Yes.
Do you have that for every
I do.
office? Because I think that would be helpful. You said 43% of the treasurer's office is at will?
Correct.
What are the others?
Secretary of State is 13%. State auditors, 26%. Department of Education is 8%. They also have the largest staff since the combination of the Department of Education and the superintendent's office. So we're talking about 243, I believe, permanent employees with all of them together. Or 243 employees. And then the permanent side might be closer to what the 200, what they were talking about. So during the testimony on the House side, the focus that I've kind of worked on here was classification or reclassification, flexibility in that area. Directions to reassign staff, the ability to reward employees as the governor's office mentioned, and more efficient classification process. One of the things that was cited was a 14-month delay in the chief operating officer position at the treasurer's office. And I think that has been somewhat addressed. It was addressed on the floor in the House that was the legislators' fault. Not a fault, but it was between the governor's office and when Representative Nicholas came up in the JAC, they were going back and forth. Really had not anything to do with HRD, except we tend to be the control agency, so we have thick skin. So we are a control agency, and I think there's a few things that this committee should be aware of. The at-will, we've discussed at length, and I think everybody's understands that issue. And the one thing I will mention, in 2011, there was a House Bill 252, and that was the at-will study for the entire executive branch. And that's when they came up with the understanding on at-will for the electeds and where we wanted to be there. At-will, for example, if you are the state treasurer or the auditor and you have an at-will position, you don't have to go through the recruitment process. You can appoint them. If I wanted to appoint an HRD administrator, I don't have to go through that process. I can say, I want this person, I'm going to put him in it. That's how easy it is for that process. Now, when you get into the classifications, it gets a little harder, but we have to remember that we follow the rules to a T. And as Ms. Anderson indicated, sometimes the governor's not real happy with me on following the rules, but they do. It is, quote, bureaucracy that we've talked about, but it keeps everybody on an even playing field. And it keeps everybody out of trouble. The one thing that you need to make sure that you have in these situations is somebody you can say, and what I used to tell my folks is like, did you call the AG's office? Because that's cover. As long as you called them, it's cover. As long as they called HRD, it's cover for them. So I think when we look at the reclassifications, one outlier, the 14 months, is not the norm for HRD. Our norm for the state auditor's office was 15 days for a reclass. For the treasurer's office, it was 14 days. For Secretary of State's, it was 36 days. There was an external review for ETS, took a little longer. But we've totaled, we have a total of how many? I believe there was 107 reclasses requested from all 4 electeds from 2018 to current. And there were only a handful, I believe there were 7 that we disagreed with. The rest of them skated right through. So I want to make sure it's understood that when the legislature and the JAC talk about compensation, we implement what the JAC has approved. So for example, the phase 3, phase 2, phase 1 compensation, that comes from the governor setting out what he wants in his budget, the JAC saying yes to all of it, or hey, we're going to give you 3/4 of it, we're going to give you half, and you guys have to figure it out. We follow what the JAC wants us to do, what the governor wants us to do. And that's where we tend to get into an issue. When you want to reclass a position from an attorney, for example, that the treasurer was talking about, the deputy, to an executive management position, which is what they want that position to go to, we want it to be in the attorney study because we don't know if that would fit or not. But if you do that, do you have the money to pay them that rate? Most agencies don't, and that's what happens. It's not necessarily a classification issue, it's a budget issue. If you don't have the budget to pay up to that classification, HRD is going to say no, because we don't want to back the JAC into a corner for the next time an agency comes up and says, well, HRD classified it, that's what they told us to do, and now we need money. So we have to play that very close when we're working on classifications. So I wanted to make sure that you understood how that, and I know you understand how that works, but the legislature and the JAC are strictly involved. And we implement it and we control it. And that's what, all agencies, nobody wants to be controlled on some of this stuff. But when you don't have the money and we say, sure, go ahead, you can put it in an EXMT. And then they come back to the JAC and say, well, we need an additional $20,000. Well, why do you need that for that position? Well, HRD reclassed it to an EXMT. That's usually how the testimony goes. So we don't like to do that, and we don't, unless it's an emergency and they're willing to go in front of the JAC and say why they had to do it, we don't do that. So you'll see that throughout, which is why we stick to the classification schedule, because that is what we have told the JAC, and that's what we've told the governor will do. I just want to make sure I hit everything. The two positions, I guess I should have said in the very beginning that I'm neutral on the bill. I just want to make sure that you have some facts. And the two positions, for example, when we research what the best practice is for an HR employee, so for an 8, for example, permanent employee, 8, they can handle 250 employees. So when we talk about 2 employees for all 4 electeds, that's double what we would have currently for the rest of the executive branch agencies. So a manager has 1,000 employees, and then a 8 or I can't remember what the classification is called, but it is an 8, is 250 employees. So I do think 1 employee would cover all of the, especially since the majority of them are at will, that we can cut out of there. And if it's 200 employees, I think in 1 position is enough. That's what we have. So I don't think I have anything else, and Aaron might be able to bat some cleanup for me if I made any mistakes. Do you have any questions for me?
Any questions, committee? All right, got a couple more minutes. If you want to share anything with us, that'd be fine.
Chairman Olson, members of the committee, my name is Erin Williams. I'm currently the Human Resources Division Administrator. I just wanted to point out, we echo the concerns of the elected officials when it comes to the compensation and the pay tables. I think we've been very successful with the governor's office and the legislature getting caught up. We were extremely far behind on compensation. However, we know there are some very difficult to recruit and retain classifications and occupations still. And we're on the 2022 pay tables, not the 2024 pay tables. So we echo and hear those concerns. We definitely don't discount what the elected officials are saying. The issue that the Human Resources Division runs into is we have to worry about equity and getting those pay tables fair and equitable for 7,500 state employees. The issue with the attorney study, we have known and agreed with the entities, the DA's office, the AG's office, the elected officials who have attorneys, that structure is definitely in need of an overhaul. And so we have definitely had the attorney study on our radar for quite some time. We had some additional studies and reviews that got that off of our timeline. We were legislatively authorized to look at the positions in the Department of Audit. We also assisted the Business Council and the Judicial with some of their compensation reviews in order to accommodate them with a phase 1 and phase 2. So Deputy Director Williams is correct that we deviated from that timeline. However, I would like to point out in phase 1 and phase 2, we identified that the attorneys were drastically underpaid. They were one of our occupations that when we were falling further behind on market was one of the most highly affected occupational groups. So they were given separate additional allocations out of the funding to get those employees up to where we could with the additional funding that we had to assist the agencies with recruiting and retention of attorneys. We are now doing the study, and some agencies have requested that we look at individual positions before the end of the study is done. We're not sure where those classifications are going to come out, so we have also accommodated the agencies. Those employees currently are receiving an add-on, an additional duty pay until we can accurately assess their appropriate classification.
Any questions for Ms. Williams? All right, thank you. Is there any other public testimony? None. Anything online, Pierre? I will close public testimony. Committee, what is your pleasure? It's been moved by Senator Kolb. A couple of amendments. The first one is a technical correction on page 4, line 5. Ann should delete the N so that it reads, make any employee of a state official. I guess that's not even really technical, but it is grammatical.
Can I vote no?
I'd entertain that motion.
So moved.
Okay, it's been moved. There was some discussion on it about having permission to vote no. All those in favor signify by saying aye.
Aye.
Any opposed? All right. The other amendment is pretty substantive and it is in written form, so you should have received what's just marked as amendment number 1 to 324. This amendment deals with the discussion that we had with each department. The main thing that it does is on lines 3 through 5 of the amendment. It specifically gives each state official the authority to determine which employees are at will and which are not. This appears to be the preferred language amongst the departments, so I would entertain this motion. No?
Mr.
You
Chair-
don't count.
Yeah, I know, Mr. Chairman. So it doesn't, I've read through the amendment. I don't think we may have to just do this at later, because it does not actually do what I think we were trying to do, which is say that essentially it just, I'm worried about making employees at will. And essentially it says on or after July 2025. The electeds get to decide who and what are at-will employees, and the testimony we heard today from several of the electeds is they're fine with the way it is right now, and this doesn't really do that. And so I guess I'm not in favor of the proposed amendment, so I won't be moving it.
So we may need to work, well, not you, but we may need to work on this amendment apparently. This amendment was provided to us by one of the departments, so I penciled it in. I guess I don't fully understand your comments.
So, Mr. Chairman, I guess when I had talked to one of the electeds, is that my problem with it is we're not getting away from, I wanted to get away from even really discussing at-wills within the bill draft and just focus on giving the electeds the ability to determine, essentially give them similar authority that the chief executive has to decide salaries within their particular offices and be able to move some things around and have some flexibility, but that's not really what this amendment does. So, and I think Senator Kolb has some concerns about it too, but for example, you go down to page 2, lines 16 through 19, the amendment does not take that out. And it's still, so it says the employee state official retains the absolute right to terminate any employee. That makes everybody, that language does not come out with the amendment. And so that means every employee remains at will within those 4 offices. And I'm not, I guess I'm not in favor of that, Mr. Chairman. Thank you.
Okay. You could always delete that.
Mr. Chairman, you could, but that doesn't fix the language above that either. I mean, we're still saying, if you look at the language, I think we're still saying that they get to determine who's at will and who isn't.
Senator Kolb?
Yeah, Mr. Chairman, I have the exact opposite point of view here. I think they should all be at will. I have a huge history behind me of dealing with this over years. So I realize it's problematic no matter which way you go. However, for the sake of an elected position, they oftentimes do run into issues. And, it isn't because they're a Republican and someone's a Democrat, it's because they're hostile to the office environment and frankly, spewing hate and discontent and causing a ruckus in the office. So I think the bill is written. I'm fine with it as written. So no, I'm not going to move the amendment either.
Okie dokie. For 2 different reasons, we're not going to move this
2
amendment.
opposite reasons.
I'm stuck in the middle. All right. Any other amendments to this bill from Senator Kolb?
Just one more that was spoken about the positions, Mr. Chairman. On page 4, up here on line 16 down to line 18, basically cutting that from 2 to 1, which would be make the amendment that we go from $236,720 to $118,360, which is exactly half. And then on the line 18, strike 2 and put 1 and also the conforming language that would align with one full-time legislatively authorized employee for the HR. Because I think once you start talking about the HR, I mean, it went from 2 to 1 for every office of elected people, which I find frankly ridiculous. So I think 1 is appropriate, but I don't know if this is the right place to make that amendment. It seems,
Well, I think it is. There was just 2 different types of testimony on this. There was testimony that each department should have its own HR, and there would be 3 total HRs with the auditor and the Department of Education sharing HR, and then the treasurer and secretary each having their own HR. And then there was testimony that it could all be done by 1 employee. You're of the position that it can all be done by 1.
I do, and it's for uniformity. That's the reason why I'm in that position, because as soon as you start breaking it up, you're gonna have, all the empires with their separate way of doing things. And I think that's not advantageous for state government. It's precarious enough when we start splitting it from A&I and having their own HR people. I mean, I think this would be a compromise where you just have 1 unified person over the separately electeds instead of, 1 per each. That's the other extreme. So I thought it would be a compromise, and, I don't know if it's gonna work on the floor or not, but I don't know why you need more than 1 person to handle these many people. I don't know what they'd be doing in their spare time while there isn't an HR issue. So it seems reasonable for 1 position, Mr. Chairman, and I'd make that motion.
Okay. Any other discussion? Question on the motion? That's the amendment. Discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed?
No.
No? Okay.
I'll say aye again. Would that be a tie?
Twice, you can say it twice.
Yeah, we can say it twice.
Okay. Other amendments to this bill? Discussion on this bill?
Question.
Senator Craigo?
Mr. Chairman, so I'm probably going to be a no on this because I don't think it's not really getting to the heart of what I think we're trying to do. And then we have all sorts of these other issues regarding the at-will issue. And I'm sympathetic to our other electeds. I'd like to find a solution to help them solve this problem because I understand. I think we even heard from A&I that there's some issues there, but I don't think this bill is going to solve that. And I'm not sure how to get there and if that's something we can do through the budgetary process, if it has to be in a bill. But this one's, to me, seems overbroad and we're trying to, I think we need to zero in on what really is important here, which is giving you the flexibility to do what you need to do within your office without having to jump through 8 million hoops. That's what I want to do. But I'm not sure that's what this bill, at the end, I'm not sure that's where we're going to go with this bill. And I think it might create more problems for you than it solves. And so just so you know, that's where I am. I'm all on board, moving forward, helping you solve that problem. But I'm probably a no on this bill because I don't think that's where we're going to end up. Thank you, Mr. Chairman.
You have about 5 seconds to decide.
Yeah, I'm a no.
Oh,
So-
you said probably. So-
Yeah. Thank you, Mr. Chairman, for that.
Okay. All right. Pierre, will you please do a roll call vote on House Bill 324?
Senator Craigo,
No.
Senator Crum,
Excused.
Senator Hicks,
Excused.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
2 ayes, 1 no, 2 excused.
Okay.
Do pass amended.
All right. That's all we have. Thank you. We'll see each other tomorrow.